In the previous video, I discussed researching forms in the law and procedure, and so now you've done that and perhaps filed a petition or you were served with one. Now it's time to prepare for the conference, hearing, and/or trial. How do we do that? Let's discuss it. I am Larry DeMarco, and I'm a family law, personal injury, and workers' compensation attorney. In preparing your case, ask yourself 3 questions. 1, what do I want the judge to order? 2, why should the judge give it to me? And 3, how am I going to prove that I'm entitled to it? So the analysis is what, why, and how. First, let's consider the what. Let's say you filed a petition for partial custody because you want to see your child more. Consider exactly what you want the judge to order and write it out in a short, clear statement. Specifically, what you're going to request in terms of day, time, or weekly schedule. Everything and anything you prepare relating to the why and the how, the second 2 parts after you do this, should relate back and support that what that you're asking for. Suppose you only have every other weekend and one night every other week and you want 50-50. Or the other parent won't let you see your child and uses bad excuses to give you less and less time and deny you access. So for more time, you write every weekend, Friday after work to Monday morning before school. And summers at my house, and the other parent gets every other weekend during that summer. So that's the what. And the why and how will be drafted in support of that agenda. Don't waste time on arguing about or thinking about things that aren't related to your what. For instance, if you want every weekend and your ex only wants you to have every other weekend, you're not going to bring up that your ex cheated on you when you both were married, or the ex gets drunk and goes out dancing and partying until 2 a.m. on the weekends when that person doesn't have a child. It's irrelevant, distracting, and the judge doesn't care. You're only going to discuss why your home is a good place to be every weekend and during the summer. Going to family court isn't like negotiating the price of a car where the dealer makes up the price and you lowball and the 2 sides then split the difference or compromise at the end. It's more like baseball arbitration where each side submits their best reasonable proposal and the judge picks one or the other. If you're unreasonable and your ex is reasonable, you're much more likely to lose. If you come in with something realistic, you're more likely to get what you want. Now let's discuss the why. This is more involved. The why are the reasons you'll give when you try to persuade someone that you should get what you want. It's your explanation of why you're reasonable. For instance, let's go back to that other example of you trying to get every weekend rather than every other weekend. So in that example, suppose you work a full 40 or 50-hour week from Monday to Friday and your weekends are free, and your ex has the child 5 days a week and is only working part-time. So in your proposal, the child will have equally quality time with both parents, even factoring in those work schedules. When preparing the why, just list the simple reasons without going into detail about the evidence or testimony. That's the next part, the how. After you're confident on what you're asking for, and with the reasons that you'll give for the why you should get it, then you plan and prepare that third step, the how. Write out, gather, and organize how you're going to present your case. The relevant evidence, text messages, pictures, emails, stories, testimony, and witnesses you'll bring into court with you to testify that's in the child's best interests for you to get what you want. Include everything that supports your position. Forget how awful the other parent treats you. Focus on the evidence that supports what you want. Judges don't want to waste a lot of time hearing about how bad people are. They're usually persuaded by the positive. Be as detailed as you can and in describing the testimony that you'll personally give and what arguments you'll make. after you've written everything out, put down your notes and all the work for a few days. Cool off and take another look, especially if you're feeling strong emotion or passion while you were preparing that document, and allow a cooling off period before memorizing and rehearsing anything that you want to say in court. Discuss your ideas with your support network, parents, best friends, therapist or counselor, or other trusted source. It's also good to get a consultation from a lawyer or some trusted advisor so you have another person, another perspective outside your own. After you're confident in what you want to say, practice out loud and rehearse as if you're in the hearing room itself. Do it enough until you can talk naturally and not like you're reading a book. Ideally, you'll want to appear like you're conversing and only checking your notes out once in a while to be sure that you've covered anything. So in summary, we've got a 3-step process organizing the what, the why, and the how. Draft and write notes down in support of each. After you've done that, wait and then review. Do this with someone else and revise and practice. If you do all that, you'll show that you care enough to prepare and you'll stand out. You'll have a better chance at a good result. I hope you found this video helpful. Please check out other informational videos on my YouTube channel. Like, subscribe, and click the notification bell for new videos. To learn more about my legal services, click the links in the description section of this YouTube video or on one of the video links on your screen. Thanks for watching. Bye for now.